Now, the values that are set out in the Electoral Commission INEC's mission statement include autonomy, transparency, integrity, credibility, impartiality, equity, and excellence. In fact, INEC is supposed to be the custodian of Nigeria's democracy. Yet most Nigerians believe that in the very process of securing that democracy through free and fair elections, INEC has actually been undermining it in a way that is not only criminally perverse, but is breathtakingly hypocritical. Add to this the continuing anxiety over an interested party such as the President of Nigeria being the one to make key staff appointments at INEC, and you've got the recipe for what prevails today between the public and the Commission, which is collapsing trust. One civil society activist suggested that the extent of the destruction that is being wrought on this country's democracy is now on an extraordinary scale. And in that regard, Jega Africa, a civil society group dedicated to the promotion of democratic governance, is collaborating with the Senate and House committees on electoral matters to host a citizens' town hall on electoral reforms on Tuesday, amid the frantic calls for root and branch reforms at INEC. So, can Nigeria ever get it right? Well, for his take on this, I'm joined now in the studio by the lawyer and former Director of Legal Services and Voter Education at the Electoral Commission, INEC, Osaze Uzzi Oluwole, who is now, I'm told, the Attorney General of Edo State. Congratulations, because I haven't seen you. It's been about 6 months.
About 6 months, yes.
But
thank you.
Really good stuff on your part. But we still like your knowledge of INEC, and I think it's still of great value to this country and your take on what is going on. And in that light, what is your assessment of how alienated from and distrustful of INEC Nigerians have become since the 2023 presidential election? Thank you,
Charles. Expectations were quite high about the ability of INEC to deliver on its mandate, raised partly by INEC itself with its performance in the off-cycle elections, governorship elections, leading up to the 2023 general elections. So if you see, starting from Edo, Ondo, Osun, Ekiti, I think expectations were quite high, especially with the introduction of more technology, the passage of the Electoral Act in 2022, and the fact that people could view their results online, not real time, but INEC promised that they would be able to view these results real time. They were able to view these results in Edo, in Ondo, and those off-cycle elections. And I think technology worked fairly well. There was less interference in the process, and I think those elections were judged relatively free and comparatively fair. So expectations were quite high. The off-cycle elections, yes, I believe.
Okay, yeah, the off-cycle elections,
I believe
not
so.
the presidential election.
Well, it depends on which side of the divide you stand, but a lot of Nigerians seem to have had their expectations dashed by the commission, by the non-transmission of results, and by the outcome of the election. So hopes were dashed. So there's a wide gulf between what people perceive INEC to have delivered, what they promised and what they delivered. There's a wide gulf, and I think that's the challenge for us now. How do you begin to rebuild the trust of the citizens in that institution? Already in the other institutions, and I don't agree that INEC is a custodian of Nigerian democracy. Elections are just a little part of democracy, you know, and there are other pillars of democracy. An essential one, the basic one. Without that, there's no democracy. And so it's a foundation of democracy. Elections, the ability of people to choose their leaders at periodic intervals is the very foundation of democracy. Absolutely. So every other thing stands on that foundation. So and INEC is the custodian of that. So in that sense, extended sense, you can say in a broad sense that INEC is the foundation, is the custodian of our democracy. If INEC gets it wrong, our democracy is faulty. The structure cannot stand.
Right.
So yes, expectations were very, very high. And because of that, with what transpired at the end of the day, I think a lot of Nigerians were disappointed. A measure of that is the fact that even with the INEC release results for the presidential elections, for example, you'll find out that 2/3 of the people did not vote for the acclaimed or declared winner of the election. So already a foundation for that is being called to question. And people believe that because of what they saw, especially on social media. I don't know how accurate most of those things are. Apparently when he went to the tribunal, some of those things were not proven. When the Court of Appeal and then the Supreme Court, some of those things were not proven. So, but people have had, your perception is already made. And because of your inability to deliver on the mandate which you promised and live up to the promises you made, people lost trust in the commission.
And let's talk about what has happened in Kano, for example, just a few days ago, where INEC is being held responsible for the muddle over the two issues there. One was whether Governor Yusuf was a member of the NNPP when he was elected. And the other was whether the ballots that were used, some 165,000 of them, were legally valid. In both circumstances, they were INEC's responsibility to do its proper checks and carry out its functions, weren't they?
On the second one, on the latter, maybe so. Let's take one first. Let's take that of the membership of the political party. The way INEC ascertains whether you're a member of the political party, so the courts, the Supreme Court, all the courts have said the only way of, it's only the political parties who can say who their members are.
Yeah. Which is why everybody is surprised that
indeed,
when the political party said he's our member, and someone is saying, well, he isn't.
Yes. And how does INEC determine this? INEC has the responsibility of monitoring political parties, not just conduct of elections. In the process of conduct,
absolutely,
these are part of the things it does. It monitors political parties.
Absolutely.
And how does it ascertain whether you're a member of a party? I think there are two ways, basically. The first is that, first of all, you're told by the party that this gentleman is our member. Now, okay, sure, fair enough. Prima facie, I take your word for it. But what do you have to show to me that is your member? Then the requirement is that you submit your membership card along with your form of personal particulars when you are contesting the election. So I believe that, and I think that membership card will have been there. Now, 30 days before the election, you are required, for the primaries, you are required to also submit a register of voters who are members of your members of the party.
Right.
So you're supposed to submit that. So if INEC sees the membership card, it presumes, and rightly so, so you cannot blame it if a person presents a membership card saying, and it's a letter from the political party uploading his details and saying, this one is a member, this is his membership card. So I don't think INEC can be held responsible for that. I really don't know why the court said it did, maybe because his name wasn't on the membership register 30 days to the election. But that ordinarily may not be. There's nothing preventing somebody from, what is relevant is that he's a member at the time of the nomination. And the party writes and says, this one is a member. I don't think anybody can really question.
You would have thought that they're entitled to know who their
members are. If you don't know, who will know?
Right.
So that's number one. So I don't think it can be blamed.
Right.
But for the non-stamping and non-signing of the ballot papers, that has been a requirement of the Electoral Act ever since, I think, elections for a long time, decades now.
So what do you think happened there?
I really don't know. I really don't know. It's a huge number, 160-something thousand out of how many people who voted. That's a sizable number.
It is.
And the reason, first of all, why you say they should do this is to authenticate the ballot paper, to show that the presiding officers saw the ballot paper, were the ones who duly issued the ballot papers. When you issue the ballot paper, the presiding officer looks at it, tears the ballot paper, stamps and signs before he hands it over to you to authenticate it. So you don't bring ballot papers from anywhere or from the back side. So it's a prerequisite, it's a requirement, and that squarely will be with the commission. They did not train the staff properly, the presiding officers, mainly members of the National Youth Service Corps. They did not train them properly. Was there something untoward that happened? We cannot speculate.
Well, that's a good point, because you have to wonder why, in spite of the fact that INEC must have known that this is not the legal way to do it, it still admitted those ballot papers.
Yes, it did.
You see what I mean?
Yes. Maybe it presumed that they were, but it probably had the duty to, the presiding officer had the duty to check those things even at the time. Right. That's what we call sorting. When you're sorting out according to how people voted according to party lines, you should actually authenticate that. And obviously, it's from a whole lot of polling units, because the average number of people in polling units maximum is about 750. So 160,000. When you look at that, you're talking about how many? Over 1,000, possibly.
Absolutely,
a lot of polling units.
But so you agree then that there is a crisis of confidence in INEC, particularly when things like this happen. I mean, and you know, it's quite a a big sort of all-encompassing crisis.
It is. It sure is. And that's the duty that we have and the commission now has. Whether you like it or not, for now the law says, the constitution says, INEC should conduct elections. So if you do away with INEC, you'll have to replace it with a body. Which body do you replace it with? INEC has a duty, constitutional duty, to conduct elections. And if it has bungled things, if there's that crisis of confidence now, how do we move forward? That's actually should now be the conversation we should open. INEC has a duty to now to rebuild that confidence which has been lost.
But even before you get to that point,
yes.
I mean, I'm wondering whether you, having worked there yourself, whether you're surprised by some of the allegations that are leveled against INEC, even now, after many years of its existence. I mean, it's not a little kid anymore. I mean, it's almost middle-aged as far as Nigeria's
democracy. It's 25 years old, yes.
Is concerned.
Yes.
Where Nigerians should be able to trust that the Commission is not only doing a reasonably good job, but post-mortems and post-election analysis to correct the things that have gone wrong in the past. But they just seem to be like they're on a treadmill of sort of repetitive behavior.
It will appear so. Lots of things are like that recurring decimal. Logistics, trust, conduct of elections, partisanship or allegations of partisanship. By the way, regardless of what commission or whatever name so called, from Federal Electoral Commission to FEDECO to NEC to NECON to INEC, a lot of the allegations have been the same. Some argue that we're bad losers, and then when you lose, you have to blame somebody, throw the blame somewhere else. But you're right. A lot of the things that INEC has been accused of have been there all over from time. And don't forget that there's been considerable change of personnel, not just, especially with the commission itself. We had in 1998, Justice Akpata was the first chairman, and he had a commission. He died in office in January of 2000. Dr. Abel Gubada came in May 2000 to 2005. Basically with the same sets of national commissioners, apart from one or two others. One became a minister and one had to resign, but basically you had the same set of national commissioners. But the leadership of the commission, the chairmanship, the chief electoral commissioner changed. And then after Gubada in 2005, you had Professor Maurice Iwu, 2005-2010, but he conducted the 2007 elections, and you know the outcome of those elections. In 2010-2015, you had Professor Jega. There seemed to be some progress made. And then the first tenure of Professor Mahmud, and then now his second tenure. So there has been a considerable change, and all through those cycles, the national commissions have changed, the resident electoral commissions have changed. But somehow, some of the challenges that the commission has faced remain the same. So we probably have to interrogate that further. Why is this so? Are they all the fault of the commission itself, regardless of the change of personnel? You know, the secretariat is organic. People come, people go. I was there for quite a number of years. I've left. A lot of people that I was there with have gone. Some younger ones are rising to positions of responsibility in the commission. So that has been organic. So why is it the same thing? Is it that the people have not changed, the politicians or the political class have not changed, or we as citizens have not changed that much? But you cannot blame the citizens generally for logistics. But we've tried different things. In 1998-99, you depended on the military, you depended on the local government councils to provide vehicles, and the commission had some boats and stuff like that. But that you cannot do now, because then it was the military regime. So one would like to think they did not have partisan interests. But now you cannot rely on state government or local government councils to furnish you with, say, logistics assistance, to provide logistics assistance for you. But a lot of things have happened.
Right. But I mean, it's fascinating actually listening to you, because you've been in there, and people just see it as this sort of gigantic, opaque sort of thing that nobody quite knows what's going on inside. And that's why there's so much speculation, because I would imagine that if they held public assessments of how they performed in the last election, it would make people more comfortable. People would get a better sense of what has actually happened there. I mean, and I mean, you more than most, you know the internal workings of INEC. Why isn't that sort of thing ever happening? I mean,
Charles, let's be fair. It does happen. But do you especially when you've lost confidence in an organization, when you now want to hold a public, are you likely, or people likely to turn up to voice their concerns? That trust it permeates the whole gamut of the organization itself.
Right.
So when INEC calls people now, people say, no, INEC has done that. INEC called civil society, they called the media executives, they called political parties, they called other stakeholders. And it's been the tradition to hold postmortems after every election, after every major electoral activity, to do some kind of assessment.
Yeah, but within the organization, not in a public arena.
Well, public, they invite political parties. There's a cycle of it. First of all stakeholders, they have stakeholders engagement, starting with the political parties, going to security agencies, going on to civil society organizations, going to the media. These things were even held post-2023 elections. I think they just concluded a couple of months ago. But, and Rise covered some of those activities. But it will appear they're just talking to us, maybe you say it's a select few. Right. But INEC believes it's a wide enough gamut. It has its own internal assessments and postmortem as well with electoral officers. It's always done that. But probably or possibly, if a different body had done that, maybe people will be more confident to come there, air their views and voice their concerns. Maybe so. But don't forget that the courts themselves are, although they are technical rules, they are supposed to be like the watchdog to see, did you do these things right? Did you follow the processes? Did you follow the procedures? Did you follow the law? Yeah. But again, issues of trust as well.
Well, absolutely, because I mean, so I know that there are, obviously, you have, I mean, they meet with civil society groups, and the civil society groups come here and tell us that, yes, they talk to them, some sort of post-mortem. Yes. But it just never seems sort of like a real root and branch assessment, especially when you've got the level of mistrust and ill will, as you said, against the organizers after all that has happened. I mean, people never seem to actually know what went wrong. You see what I mean? Why is it that in certain places this didn't happen or that didn't happen? Are your people guilty? And have you penalized those people for what they've done or ensured that, you see what I mean? Anyway, tomorrow, Tuesday, for example, the civil society group Jega Africa is collaborating with the Senate and the House to host what they're calling a citizens' town hall on electoral reforms. What are the reforms that you would propose to get INEC to be truly independent and to be able to conduct free and fair elections in this country, or at least to be seen to make that sort of...
Charles, your program is less than 1 hour. If we were to discuss that, we'll probably need a whole day to do that.
Briefly.
But let me just quickly say that apart from, well, to an extent, some levels of specialized postmortems have been conducted. I think it started with the Babalakin Commission that looked into the affairs of FEDECO and came out with a report. Lemo Commission looked more at the violence, the post-election violence in 2011. That's what it did. And then before you had the Ways Reform Panel, which looked more holistically at reform generally. I'm not too sure it really did a proper post-mortem of that. Now you probably would need that, but who will champion that? Who will do that? Now, Jega is a credible organization. I've worked closely with them. Fantastic, and they work closely. They know some of the workings of INEC, and they've monitored elections for quite a while. And there are several other reputable CSO organizations that have monitored the process for quite a while. Now, but they're collaborating with the National Assembly. Now, are you sure people have that same level of trust in the National Assembly? These, don't forget, are the main beneficiaries of the outcome. I don't know. I don't want to say whether they're good or bad, but they're the beneficiaries of a process.
They're politicians.
They're politicians, first of all, and that is why when people call reform,
let's face it, have very little trust.
They have very little in politicians generally, and then the immediate beneficiaries of these elections. These elections were conducted the same day as the presidential election. So how much trust and confidence do you have even in those who are now calling for a postmortem, who are now going to examine, talking about reforms? Will the beneficiaries be so keen on changing a process that has produced this outcome, to their benefit? Some people are skeptical about that with good reason. And in your trailer, you talked about confidence in the fact that the president is a politician and he appoints recs, he appoints commissioners, he appoints national commission, appoints the chairman of the commission. Now, if you don't do that, who would appoint? A lot of the time, we don't more critically look at some of those issues. Some people say National Assembly, but the National Assembly is full of politicians. You're taking from one set of politicians and giving it to another set of politicians. Why do you think the outcome will be different?
Well, you just get, well, I suppose you have a point, because even if you set up a committee,
yes,
sort of a so-called independent committee, although you can do that, I mean, there are a lot of very reputable people within Nigeria.
And how would they be appointed?
That you can bring. Yeah, that's a good point, because it would still be the executive that would make that appointment.
Yes.
Or, you know, and there'd be allegations and accusations and so on.
Yes.
But I think that in terms of the optics,
yes,
if you started by saying, you know, and this would obviously come as a result of consultations and so on, let's remove this from a president who has vested interests
yes,
in the election,
the outcome,
and find an alternative.
Yes.
That presumably would raise the level of confidence in that particular chairman of INEC and all the rest of it.
On a peripheral level, on a superficial level, probably so. But when you look and scratch beyond the surface a little bit, then you have a problem. You'll find out some of those things. You said root and branch just now. You really have to go deep down. And it should be more than the optics. It should be something substantive. It's not perception. The reality, we should look at the reality of the thing. Some people say the NJC, the National Judicial Council.
Yeah, I was thinking of the judiciary.
Yeah, but who appoints the Chief Justice of Nigeria? It's the president. And the president appoints most of those members of the NJC. This is a part of the issue. So you're going around in cycles probably, because people don't think, and the appointment of judges has become very, very controversial and political as well. People feel that way. So we've had our own fair share in the bar. We've had our own fair share of certain appointments made to the judiciary.
But do you think it's not enough? You know, you've talked about post-mortems on a fairly sort of, you know, simple level,
yes,
if I might call it that. I mean, do you think perhaps an inquiry, because if this was any other country, I mean, you'd see that sort of thing. Yes. An inquiry should be ordered into INEC, for example, by the Attorney General, or over possible misconduct, or whether any electoral or criminal offences have been committed in recent elections by members of the Commission. I mean, you're an Attorney General yourself now for a state.
But some will argue I'm a beneficiary, indirectly a beneficiary of the outcome.
Yeah, because you were appointed
by somebody who was elected.
Right.
Yes, although we did not take part in these elections in terms of the governorship elections coming in November next year. But you're right. I think there's this concept of the independent counsel in the US. And I think there are certain parliamentary committees have a lot of powers as well to conduct certain inquiries. And technically and theoretically, the National Assembly can conduct a lot of inquiries, especially into corruption, wastage, and stuff like that.
They've got oversight functions.
They've got oversight functions in that regard. But once they start going into criminality, you're likely to go and get an injunction from a lawyer saying that, look, you cannot do that. That is beyond you. There's a criminal case. You go and take the proper thing. Only the courts can determine culpability of an offense known to law. But yes, we do need, I don't know how we're going to devise that, we do need, for example, and more importantly, I feel strongly about that, for example, that even up to times of tribunal has only said that, look, there were technical glitches. Nobody has explained what those technical glitches are. And it's possible that maybe an inquiry will unravel what actually transpired. And I think Nigerians are very interested.
Yeah, because that's a very broad term.
It is a very broad term. That's why perceptions, some people feel, no, not technical glitch. It was a human glitch, a deliberate human glitch. I don't know, but fair enough, we want to give INEC benefit of the doubt. And something untoward happened. As such, we could not comply with the requirements and the guidelines of the commission itself. I think Nigerians ought to know what are those glitches, what really happened. And only an in-depth inquiry by an independent body. I thought INEC should also probably do that itself. You know, people might not believe it.
Publish a report, even if they don't believe it, but at least let them be seen to be doing something about that in a very sort of, you know, really far-reaching way.
Yes, yes. And before 2027, already people are speaking of 2027. I think we should. That is something that we might have to do. I read in the papers and listened to news about the Senate promising to reform the act and make transmission mandatory. even though the courts have more or less said so, I don't think it can be stronger than what we have in the law presently, saying before you start the process of collation, you should make sure the results transmitted from the polling unit tallies in terms of total number of accredited voters, total number of scores of each political party, tallies with what you have. It's difficult to get that stronger.
But I mean, you could, for example, when you were talking about the appointment, and that's a very good point you made, the appointment of the chairman, the commissioners, and all the rest of it, which is done by the president.
Yes.
I mean, would it be possible, for instance, to get a respected body? You see what I mean? You've got the Nigerian Economic Summit Group, you've got the Nigerian Bar Association, you've got, you see what I mean? Groups like that to say, can you vet these people, make this public, let them apply, vet them, make a recommendation to whoever, the Senate or something, who then decides. So you've got a short list out of which any of the people that you pick would be seen to be independent. You see what I mean?
Yeah, it's near the South African example, but let's just look at each group. Nigerian Economic Summit Group. Well respected.
I just use that.
Yeah,
as
I know,
an example.
but
I mean, but more the NBA probably, or somebody like
NBA
that.
is not as monolithic, it's not as united as you think it is, and unfortunately and regrettably, a lot of the NBA elections have ended up in courts. A simple thing as choosing its own leadership. President has sadly and regrettably ended up in court. And there are lots of division within the NBA. But yes, the NBA, I believe, I'm a member of it, a strong member of the NBA, should be probably, and such other professional organizations, because the doctors will now challenge me, and accountants, should probably have NUJ, everybody will probably say, look, we should have a say as to how this is, how these things are determined. And yes, you can set up a screening committee. The modalities, we have to think of the modalities, how this committee will come into being. And who do they submit their report to? And what will be the yardstick for appointments? But don't forget that in appointing the INEC chairman, it has to go before the Council of States. Now, that is supposed to be the most respected leaders of the country, consisting of past leaders of the country, the Attorney General, and one or two other, and President of the country. Now, but it does pass through that stage. And although the word uses consult, that the president has to consult them. And invariably, we've not heard of anybody that the president has nominated, that the Council of State has said, no, we don't think this person is good enough for this job. We've never had that. There ought to be some kind of filtration process. And everybody agrees on that. But what we don't agree on, what kind of filtration process should that be? Who should consider that filtration process? Who should have a say? In South Africa, it's parliament, and it's advertised. Well, you know, when you advertise, all sorts of people will apply, qualified, non-qualified, and other people will be sponsored. That's the truth of the matter. They will be sponsored. And let us not lose sight of the fact that many countries don't even go this way. In some of the more advanced democracies, in Scandinavia and the UK, the electoral commissions, in the US, the electoral commissions do not conduct elections. In the US, some states, the lieutenant governor, which is the deputy governor. In some states, the secretary of state, the attorney general of the state conducts the elections. I don't think we've reached that stage where people will be confident if that was the case. So we opted for the option, like most developing democracies, of having a strong, independent electoral management body to do that.
Right. Okay, very interesting. But please don't go away, because we want to talk with you some more. You're watching Arise Prime Time. Plenty more still ahead. We'll discuss the conferment of the prestigious title of Senior Advocate of Nigeria, which has today been taking place in Abuja. Stay with us. Welcome back to Arise Prime Time, where we offer perspectives on the news and talking points of the day. I'm Charles Anyegolu. Now, they are called members of the inner bar, those who have the privilege of being awarded the prestigious rank of Senior Advocate of Nigeria, or SAN, and the latest batch have today been inaugurated by the Chief Justice of Nigeria. But amid the celebrations, there are suggestions that those who are successfully conferred sometimes get preferential treatment, and that the process is rigged, allegations that have been denied by the awarding body known as the Legal Practitioners Privileges Committee, or LPPC. Some critical lawyers have also suggested that the award creates an artificial market for an exclusive group, allowing them to charge higher fees in a profession that should be purely competitive. But supporters point to the value of SANs as a kite mark for quality in the legal profession, and to the principle of having a strong advocate in court. So what are the criteria for the conferment of the rank of SAN? Well, joining me now in the studio is, of course, the former chairman of the editorial board of Daily Trust newspaper, Mahmud Jega, and still with me, the distinguished lawyer and now Attorney General of Edo State, Osaze Uzzi Oluwole. Thank you very much indeed to both of you for coming in. And let me start by, since you're a lawyer, let me start by asking you, the rank of Senior Advocate of Nigeria is awarded as a mark of excellence for members of the legal profession who have distinguished themselves.
Yes.
But you're not a SAN, but you've distinguished yourself.
Well, to be modest of me to see what I have or I haven't, and there are certain criteria which I have not met because I did take a detour. My call to national assignment, I wasn't practicing law for a while. I wasn't practicing in terms of litigation and going to court.
But they give it to academics as well, and people who generally...
those who teach law and publish quite a bit about law. And before, there was no limit, but now the process is always going reform. And part of it, every year, it's only limited to one academic per year. So only one academic can be conferred with that rank. It's interesting to know that America doesn't believe in titles, so you don't have that in the US, but we borrowed it from the UK system, where you have a Queen's Counsel or King's Counsel as it is now. So that is a throwback to and that's how it was in Nigeria prior to now. Queen's Counsel, because the Queen was His Majesty before Nigeria became a republic and before we changed it to Senior Advocate. It is a mark of honor, mark of respect for those who regularly go to court. So if you have distinguished yourself in the academia, they will take one in a year, but if you are in any other commercial lawyers don't get senior advocates except they now start going to court. So you must have met a certain minimum requirements of appearances before the Supreme Court, Court of Appeal, and the High Court as well, before you can be considered. And it's an anomalous situation where you say that it's a privilege, an honor conferred on you, but you must also apply for it.
Right.
It's one of those odd things that it's an honor you have to apply for. If you meet the criteria, then you apply and pay money for it. If you don't meet the criteria, there's no point applying for it. So it's not just how it used to be, where you call upon and say, look, Mr. X or Mr. Y has this. We believe that it's due an honor, so we'll confer an honor. We confer it on him. All other honors in this country, you don't apply for it. It's conferred on you. But in this case, you have to apply for it before it's conferred on you. So if you don't apply, and recall that Chief Kano informed me after a while, after several applications, and he thought he was being denied for other reasons rather than political reasons. He said he chose not to apply until he was more or less, I don't know, he was compelled, persuaded to just put in an application before it was finally conferred with the honor and the mark of respect. Well,
I mean, Mahmud Jega, you've had a lot of experience as a senior journalist in this country. I mean, you've seen a lot of these SANs, and just as Mr. Oluwole was saying that there is a sense that, I mean, some petitions are actually rejected, but for a whole variety of reasons. I mean, what is your take on the SAN sort of business?
Well, I'm not, as you said, a lawyer, but I know that in previous years, the SANs used to be much fewer than they are now. And really, 10, 20 years ago, when they were so few, anybody could see that they were solid guys, you know, very big lawyers. But in recent years, the number increased very much. And inevitably, it affects perceptions of quality and cost and others. Probably the SANs of today may not generate as much respect as the SANs of 20, not to mention 30 years ago, when they were very few. But that's okay. It's a work in progress. And the law profession can continue refining its methods.
So what are the privileges that one would enjoy by becoming a SAN? I mean, apart from wearing silk, you see what I mean? And all the rest of it. I mean, sitting in front of the court or whatever. You know,
there's so many, and it starts from where what you mentioned. You wear silk, you wear a different robe and quality, and but you sit in front, and you have the privilege of having your cases mentioned first out of turn. So the Silk is there. You mentioned his own case first. It's a privilege. So you are given privileges that go with that rank, and you're accorded some of those things, right of audience, and generally you get more respect from the judges themselves. That, look, this person has distinguished himself, so he gets a lot more regards, a lot more respect. Some people say undue advantage is taken of the fact, but in every privilege, in every opportunity of privilege, even in a traditional settings, so when the chief walks into a place or you want to break cool and the chief has that privilege of doing so. So we do, traditionally even, we do respect certain conferment of certain honors on certain individuals.
Yeah, but I mean, to take that further, you get to make a lot more money, don't you? I mean, you get to charge higher fees, which is some of the things that people say. Well, in the UK, for example, there's a big argument going on right now about whether to keep the key, and it's coming from the Law Society. They're saying, well, you know, it confers unfair advantages to people in a competitive market.
Yeah, but those who hire the lawyers are not fools. Just because you are
well,
a
hopefully
son,
not.
just because you are a son, I might ask lawyers, does he win cases? Because that's the bottom line.
Yeah, that is
I want
true.
somebody who will win the case. And
the track record.
Somebody whispers to you that this son has lost all the last 10 cases. I'm not going to hire him. I'm not going to give him any money. So
yeah, but the fact that he is a SAN is likely to get him in the door, though, isn't it?
No, there is no doubt about that. But especially now, because there are so many, anybody who is aspiring to win his case in court will have to ask other questions. Just because you are wearing silk, I will have to ask, is he likely to win this case? If he will not win it, why should I pay?
Yeah, that is true. But what about these allegations that lawyers buy their way? I mean, you talked about the application, and I mean, when I mean buy, obviously they have to pay a fee in order to sort of, but what I mean is that they buy their way into things like becoming SANs or being appointed to the bench. I mean, that's an allegation that's been made from the highest sort of levels of the judiciary in this country.
Well, in a sense, and with due respect, that sounds a bit, I'm looking for the word, crude to say. But when you look at the facts of the things, then maybe there's some understanding of that, in the sense that it's not cheap to become a senior advocate of Nigeria. That's the truth of the matter. We don't charge a fee. It's a processing fee, administrative charge, really. I think currently is about ₦1 million. You know, it's difficult, extremely difficult for a poor person to become a senior advocate. That's the truth of the matter. Because the requirements, for example, if you're in private practice, you need chambers. And the kind of chambers you need, at least a duplex building. In a place like Abuja, I don't think you get any duplex for less than 10, 12, 15 million naira if you're paying rent in
and that's part of the assessment process.
Absolutely, it's part of it, because you must do chambers inspection, you must buy books, and those books cost a lot of money. You must have certain basic things in the office, and really millions and millions of naira. So a poor person is extremely difficult for a poor person, a person not of means to actually aspire not to becoming a senior advocate. Even purchase of the robes and the gowns cost as much as 10 million naira more. So really, it is not a cheap process to undergo. But some people, INEC has produced several senior advocates. The Ministry of the Police last year produced 1 or 2. There are certain organizations that produce, and so within the confines of their library is still good of their institution. So they leverage on the institution to apply and get a senior advocate. But for an average senior advocate, you have to spend millions of naira.
And what about Mahmud Jega? I mean, again, calling on your knowledge as a journalist, the allegations that have been made against senior lawyers. I mean, there have been calls for like processes of reform and all that, but there are allegations that lawyers, and in particular SANs, are also shrouded in guilt and are culpable in some of the abuses and irregularities, or perception of abuses and irregularities that we've been witnessing, because they often lead to charges that, you know, the attempt to influence judges and all the rest of it comes from somewhere, from the legal sort of the bar. You see what I mean?
Allegations are leveled. Nigerian society is really very difficult, and allegations are leveled against all kinds of professionals, all kinds of allegations against lecturers and professors, sexual harassment, sale of DBs.
Yeah, but there are lots of nuggets of truth in those allegations.
They may not be entirely false. You know, against doctors, engineers. I mean, we have building collapses in Lagos and in Abuja and other places. And those, it was supposed to be architects and engineers that erected those buildings. So, but the law is particularly painful because the pronouncements of the courts is final in many very sensitive electoral or commercial or social or land issues. And the Nigerians being who we are, if you lose a case, I mean, you are unlikely to take it lying down. You are likely to say that the judges did this, and the lawyers are classmates of the judges in school and in law school. And sometimes the allegations may not be baseless, but in many cases, honestly, they are, because people will just sit down and say things. So personally, I don't believe all the things I hear against public officers, unless you see concrete reason to believe it. Yes.
But Mr. Oluwole, I mean, there's been a lot of talk about reforming the judiciary. I wonder if, from your assessment, reforming the legal profession with regard to lawyers and SANs and all that is arguably going to help to create the space that will lead to a wider reform of the judiciary.
You must start somewhere, and the profession is probably the starting point, because judges are appointed from the profession. You have to be a lawyer and been a lawyer for 15 years before you are appointed. And it's the same thing, like the appointments to the higher bench especially require certain characteristics of the appointee. And so, yes, so you must reform the profession as a basis for further reform, a wider, broader reform of the whole process. And don't forget, even appointment of judges has become very controversial, as I alluded to earlier on. So yes, that, and by the way, this process of it's an ongoing process, organic. We keep reforming and reforming and reforming. The way lawyers were elevated to the inner bar 10 years ago is very different from what it is today, and very different from 20 years ago, and very, very different. And by the way, yes, okay, it's true that maybe a lot more people are now appointed, and you made allusions to diminished quality. Maybe so, maybe not. But the truth is that we feel that if everybody is qualified, then they should be so made. They should scale the hurdle. You don't limit the things, because all these people have been found worthy of elevation. That's why they were elevated. And you don't artificially say only 2 or 3 people or 5 or 10 people should be elevated. I think that's the argument
that's a
the
good
other
point.
people say.
Okay.
Yeah, unless that, you know, there are allegations,
very briefly,
not against
we're out of
now,
time.
but it was said, for example, that the institutes responsible for producing chartered accountants deliberately limit the number, because if there are too many chartered accountants, they are not going to be as expensive as they are right now.
On that note, I want to thank you very much indeed. Mahmud Jega is the former chairman of the editorial board of Daily Trust newspaper, and of course Osaze Oluwole, a distinguished lawyer, although he's not a SAN, and the Attorney General of Edo State. Thank you very much indeed. Very honored to have both of you. That's it for this edition of Arise Prime Time. Join us again tomorrow. From me and the entire team here in Abuja, bye-bye, and thank you for watching.